Hi, everyone. Today we are going to be discussing French employment laws. The article at hand is titled Employment Laws and the Public Sector Employer Lessons to be Learned from a Review of Lawsuits Filed Against Local Governments by P. Edward French. Here's an overview of the article. The Tennessee government has faced lawsuits against Title VII, hostile work environment, and Family and Medical Leave Act violations. Counties, municipalities, and school districts can be sued at any time. The Civil Rights Act of 1964, the Civil Rights Act of 1991, and Age Discrimination and Employment Act call into question some aspects of recruitment, selection, and promotion. Civil service has seen deregulation to avoid undeserving tenure, promotions, and seniority rather than merit, confusing employee discipline. Here are some definitions that can be important within this article. Tort Claims Act allowed citizens to sue their government for injuries caused by negligent action of federal employees in 1946. Payne versus Western and Atlanta RA Company. An employer in the private sector does not have to provide cause to an employee who is terminated. However, public employees have a unique set of legal protections. Disparate impact, the unintentional discrimination that arises from employee practices that appear neutral but adversely affect those with protected status. The study at hand analyzed 350 court cases in Tennessee, many of which dealt with the Fair Labor and Standards Act and the Americans with Disabilities Act. In the case Holiday versus the City of Chattanooga, they were suing against a police department for refusing to hire a candidate who was HIV positive. He cited the Americans with Disabilities Act and the Rehabilitation Act. The court ruled in favor of the police department, citing that each medical condition should be considered to see if it may bring harm to the public. Andrews versus City of Hookahville. The employee applied for a police officer position that he previously held twice and resigned from, and was not offered the position. He cited age and sex discrimination. The court ruled in the applicant's favor on the account of age discrimination. McDonnell Douglas Corporation versus Green sued a police department for racial discrimination, but lost. Here's some more court cases. Johnson et al. Versus the City of Memphis. The city used a written test to promote police officers, but released study materials to only a few select individuals who happened to be African American, bringing racial equality into question. Court demanded a new promotional process to be created. This caused two lawsuits, one by minority groups whose promotions were being taken away because the study materials were released to them, and one by white applicants who did not have access to study materials. Isabel et al. Versus the City of Memphis. Having a minimum score of 70% on written exams discriminated against African American candidates. Lowering the passing score to 66% would improve this standard. If a minority group is promoted at less than 80% of the rate of the majority group, that is discrimination. Even after lowering the passing rate, there was still a statistically significant rate of discrimination against minority groups. The police department had to prove that the exam was 100% related and necessary. Here are some more cases. In Firefighters United for Fairness versus the City of Memphis, this was similar to the two on the last slide, but with firefighters. Red versus Shelby County was a sexual assault case citing Title VII and Tennessee Human Rights Act. The company got off on small details. Blankenship versus Park Care Centers Incorporated. Precedent case stating that in order for a victim to win in a sexual assault case, they must prove that the industry did not take action. Harbison versus Crockett County. Female sheriff's employee ignored when she brings sexual assault allegations to light. Maynard versus the town of Monterey, sued in name of the Family and Medical Leave Act when his leave was denied to care for his infant daughter. He was not ruled in favor of because he skipped work deliberately before it was approved. Lakey versus Jackson County. Employee filed for medical discrimination because his employer terminated him due to excessive absences. Because the employee did not include documentation of his protected illnesses, he was ruled against in court. Most common laws in discrimination court cases include the Civil Rights Act, Americans with Disabilities Act, and the Age Discrimination in Employment Act. Thank you.